judgment in the appeal Morris against Ray.
This is an appeal from an interlocutor of the Court of Session in Scotland. It raises an issue of Scots law. In 2004, the respondent, Mrs. Ray, sold land to a developer called Ransom Developments Limited, whose rights were later assigned to the appellant, Mr. Morris, after the company went into liquidation. Her disposition contained the words, "and I grant warrandis." In Scots law, warrandis is a contractual warranty of title given impliedly, if not expressly, as happened in this case, by a seller to a purchaser. But the seller will only be obliged to indemnify the purchaser in respect of losses suffered as a result of a defect in title if the purchaser is evicted from the property, although actual removal is not required. When the developer attempted to complete its title to the land by registering it in the Land Register of Scotland, the keeper of the registers informed its solicitors that Mrs. Ray did not have title to part of the land which she had sold to it. That part was owned by a company called James Craig Limited, whom I shall call JCL, but the title to it was in fact held by Mr. Lynch, the disputed part having been transferred by JCL to him in error in 1991. In 2005, JCL threatened to evict the developer from the land, and the developer paid £70,000 to JCL to avoid eviction. JCL procured the grant of a disposition of the disputed part by Mr. Lynch to the developer in 2006. Its title to the land was then registered. These are the basic facts which the appellant offers to prove in his action against Mrs. Ray for breach of warrandis. Mrs. Ray attacked the relevancy of the appellant's case, arguing that even if the appellant proved everything that he offers to prove, he cannot succeed in his claim. Following a debate, the judge rejected this argument and allowed the case to proceed. Mrs. Ray appealed, and the extra division which heard the appeal by a majority dismissed the action as irrelevant. The appellant then appealed to this court. The issues in the appeal are, 1, whether the person who makes the threat of eviction has to have an unquestionable title to the property at the time when the threat is made, and 2, if not, what the purchaser has to show in order to trigger the seller's liability under the warrandis. The Supreme Court holds that it is not essential that the threat of eviction should be made by the person who has the title to the property at the time when the threat is made. In order to avoid pointless delay, expense, and litigation, the law of warrandis permits a purchaser to claim against the seller for breach of warrandis without any judicial determination. He does not have to wait to be evicted. In view of the practical purpose and rationale of the remedy, it would be wrong if the law were to maintain that the purchaser can rely on the seller's warrandis only if he accedes to a threat made by the title holder, who may have no interest in evicting the purchaser, and not by a third party, although not having obtained title, does have an interest in doing so. There must, of course, be a competing title which will prevail in a question with the purchaser. If the purchaser buys off the threat, he must be able to show that he transacted with the right person and that the threat was capable of being made effective. But it will be good enough for the person making the threat to have an incomplete title if he is undoubtedly in a position to compel the title holder to transfer the title to him, or if the threat is bought off to the purchaser. In other words, the purchaser must objectively have no realistic alternative but to accede to the threat of eviction. Whether such an alternative exists in particular circumstances must be a matter of judgment on the facts. In the present case, the appellant is offering to prove that JCL would have been immediately able to secure title to the disputed part without the need for proceedings by demanding a transfer of the title vested in Mr. Lynch, and that the developer would have had no defence to JCL's threat of eviction. He has therefore set out a relevant case against the respondents. The Supreme Court unanimously allows the appeal. The court will now adjourn.